Good day, everyone. My name is Nathan Diamond. I'm the Executive Director of the Orthodox Union Advocacy Center. And as you know, you've tuned in to a Zoom webinar briefing with myself and my good friend and colleague, especially in amicus brief writing, Professor Michael Avi Helfand of the Pepperdine Law School. As you've probably already seen from information we've sent out, this was a milestone victory in the Supreme Court last week, in a week that had a lot of big opinions. This was, in some ways, the biggest because it was the one with the 9-0 vote, I guess. And it's an issue that we at the OU have worked on for many, many years, and are very pleased with the result. So we thought it was important to convene this Zoom and explain to you and others who will see this webinar afterwards the significance of this, and also importantly, what it means in the daily lives of people in our community, and also some things that the OU is planning on undertaking to try to make sure this is implemented to maximum effect and benefit for our community. But I think probably the best place to start is to ask Professor Helfand to briefly recap what happened last week in the Supreme Court, and then we'll analyze it a bit and talk about, as I say, the next steps and the impacts for the community. So without any further ado, Avi, take it away.
Nathan, a pleasure to be here with you. You know, the last time we did a Zoom together on this subject, we were, I don't know, how would you describe us? Worried a little bit, I think, as to maybe
cautiously optimistic.
Cautiously optimistic. Maybe you were cautiously optimistic and I was worried. But in all fairness, and here I think we're likely in agreement then that we're just quite pleased with everything that happened last week. So what are the facts of the case before we talk about exactly how the Supreme Court addressed it? Gerald Groff, who was a employee for the U.S. Postal Service, he had a Sabbath observance on Sunday as an evangelical Christian. And over the years, he had been able to observe that Sabbath on Sunday until the U.S. Postal Service, presumably to generate some more funds, partnered with Amazon, and Amazon wanted the U.S. Postal Service to, during certain months at least, deliver packages on Sunday. Groff informed his supervisors he would be unable to satisfy his obligations to participate in that endeavor and deliver packages on Sunday. They tried to accommodate, but ultimately this led to his termination. He filed suit under federal law, under Title VII, and he said that his employer has an obligation to accommodate his religion. And this is the big issue, the core, the crux of the question in this area of law is how far must the employer go in order to accommodate somebody's religion? What kind of resources, efforts do they need to expend? And so Groff asks to be accommodated. The Postal Service says, we don't think we're obligated to. We don't need to go as far as we would be required to in terms of the details of what we'd have to work out internally in order to accommodate your Sabbath observance. And as a result, they terminated him. And this becomes a legal debate. Did the U.S. Postal Service have an obligation in order to accommodate Groff? And underlying that question is really an issue of the text of Title VII. The text of Title VII says an employer needs to accommodate somebody's religious practice unless it presents an undue hardship. Now, if you were just reading the words, if you handed them to somebody, they would probably say, got it. A little bit unclear as to what that means. It sounds like I need to endure as an employer hardship, just not the undue kind. And we'd have some line drawing questions. It would be a puzzle. When does hardship become undue? That would be hard in and of itself. But in 1977, the Supreme Court said, no, forget about all that. Undue hardship means it's undue hardship if an employer even has what they like to call de minimis costs. I don't know why they always use Latin at the most important moment. Even a trifling cost, even just a little bit. And that didn't seem to be what the text of Title VII said, but that's what the Supreme Court said in 1977. That meant employers could say, I'm off the hook because this is annoying. There's some administrative costs. There's even a trifling a couple of cents that I'm going to have to pay, anything really could get the employer off the hook. And this is what the Supreme Court revisited last week. Is that right? And ultimately, the Supreme Court said, well, it's not right. The standard undue hardship should mean what it says, which is unless the costs are substantial, an employer has to accommodate. And to get there, I would say the Supreme Court engaged in some interpretive fancy footwork. It didn't overturn its past decisions. It found new language in its old decisions, got super creative. Maybe not, maybe it will be for today, but probably not for today exactly how it did it. But it successfully said the old decision is still good, but we found better words, and those words generate more of an obligation on the employer. And kind of going forward, the big question is going to be, what does this mean when we say that an employer must endure costs, but not substantial costs? How does that work? How does that work in terms of context, obligation, nature of the work? All of those pieces of the puzzle, I guess, is what we'll chat about a little bit further. But those are the basic stakes of the case.
Right, and I think it's important though to also explain to people who are tuned in that before this ruling and now even after this ruling, right? It wasn't the case, and it's not the case that an employee can walk into her boss's office and say, my religion requires me to do X, and you must let me do X, or not do X, and you must not ensure I don't have to do X, right? It's still a balancing test. It's still, if it's going to impose substantial costs now, if it's going to basically be really disruptive and really, really difficult and get in the way of the business operations of the company, the employer is still not going to have to accommodate that employee. And then what's also important is, right, they couldn't make it simple and say, here's the rule and here's the standard, also because first of all, Title VII in this does not apply to really small businesses of fewer than 15 employees. This doesn't relate to those kinds of small businesses at all. But what a 25-person hardware store is going to be required or not required to do is going to be different from what Walmart or Amazon may be required or not required to do. And so people listening to this and people reading about this should understand there's still a lot of negotiation that has to happen. There's still a lot of goodwill that has to happen between managers and their employees as this goes forward. One of the interesting things about how the arguments that we put forward in the OU Advocacy Center's brief and others put forward on our side as well was saying to the court, we want you to throw out Hardison. As you say, Avi, they didn't do that I want to say they functionally threw out Hardison. Like it's still there, but it's pretty much gone, at least as how it was understood. But we urge them to adopt the standard from the Americans with Disabilities Act, which also uses the undue hardship term. And part of the argument was that's a well-established body of case law, and why don't we just transplant all of that into this context? They explicitly say we're not doing that. What are your thoughts about how the fact that they explicitly decided to not do that looks like for this situation going forward?
Yeah, I know you have you have a positive spin on it. I think what it means is that the next couple of years of litigation under this new standard are going to matter a ton. What the first couple of courts do, lower courts, when they get the first, run-of-the-mill cases and try to apply this new standard, I think it's going to really set the tone. What are courts going to be doing? Is this just a plain old cost, or is it a substantial cost? And, the data points as they come in are going to have a lot of impact because we're not using some sort of well-established set of cases from some other area of law. And because the Supreme Court, I think rightly, identified that this has to be a context-sensitive area. You've got to take into account what kind of business it is, what its needs are, what's going on. It's really a standard that asks employers to be sensible. to really try and accommodate unless you really can't. And so I think it means that we all have a lot of work to do in these first couple of years, just making sure that the advocacy continues for I'd say a balanced and intuitive application of this new standard that isn't tied to any other set of cases.
Right. One of the silver lining that I see that Avi referenced is the fact that something that you have in the Americans with Disabilities Act that you do not have in Title VII is, while they have the undue hardship language in common, they also have, ADA has a provision that talks about whether or not the employee can carry on the essential functions of the job, even after receiving the accommodation. And by not adopting ADA wholesale, that particular point doesn't necessarily come into the discussion about religious accommodations. Of course, a lower court could say, oh, wait, this is how it's handled over there, and we're going to apply it over here. But maybe that's a benefit. One of the questions I got in the day after, a couple of days after the ruling came down, was actually an interesting one to play out both of these parts of the conversation. It was from someone who's working as a medical resident at a post-medical school and part of their medical training. And residents are often cycling through rotations 7 days a week and so on. And the person asked, oh, does this mean that Shomer Shabbos residents can really have a certainly greater likelihood of not having to take shifts on Shabbos? I wonder, Avi, what you think of that particular illustrative example, because it also touches on this essential functions question in a certain sense.
Yeah, I mean, there are two things I want to say. The first is we always need to keep in mind that I think this was my reaction when we chatted about this. We need to keep in mind that there have been state laws on the books. One of the amicus briefs filed in this case from 22 states noted that, in trying to get the court comfortable with the idea that it should actually read Title VII, read the words the way they're meant to be read. It said, you may think that if you expand the obligations of employers, all hell will break loose. And just so you know, we've had an expanded standard for a very long time. And guess what hasn't happened? All hell has not broken loose. But what that does mean is that there's probably something instructive from state law on all this, all these various jurisdictions that have had expanded protections, how they've addressed all these various kinds of cases. And we'll probably be able to mine a lot of state law now in order to identify patterns and use that for federal law for states that don't have these expanded protections. So one is a methodology question. We probably have some stuff out there that as we really go through these cases, that's going to be helpful. The residence question is probably a good one. It probably also shows why a lot of the facts about a residency are going to matter. I didn't go the medical path. I'm not that kind of doctor. And that's probably because blood is not my thing. My impression, though, is that a lot of residencies are 1, 2, 3. Sometimes they're pretty small. And the smaller a residency gets, even though it's probably an employer that has more than 15 people, and so Title VII does apply. But the smaller the number of residents you have in a particular program, the harder it's going to be to really work on the shift swapping. So, the facts in any particular residency are really going to matter. If there are 2 people in a residency and one person says, I can never work on Saturday, unless the other person says, I can never work on Sunday, you may have an issue there just in terms of how difficult it would be. And that might be a substantial cost. But, in larger residencies where there are tons of folks and, Saturday is, you want somebody to work on Saturday, but they can take on Sunday shifts and really kind of work out the system. I actually think there may be a good argument. I'd like to also think that those are the residencies that are already Shomer Shabbos, but I don't have a good enough sense of it. I want to say one more interesting piece now that, as we're puzzling through the facts of a case, Supreme Court decisions, I think, as we've all come to know, have more impact than the kind of 4 corners of their ruling, so to speak. I have this friend who teaches at Hebrew U. Netta Barak Koren. She does this fascinating research, like data-driven in terms of religious liberty cases, to see before and after what their impact is. And what repeatedly her research shows is that effects of either taking advantage of a ruling or implementing a ruling go well beyond what the ruling might necessarily allow or require. And one of my great hopes is that this ruling, it will create a culture of accommodation, that this pronouncement, and not just any pronouncement, but a 9-0 pronouncement, a unanimous court, will express to employers that part of what is woven into the fabric of our marketplace is the notion of accommodation, the idea that people shouldn't have to give up certain characteristics about themselves in order to make a living. And I hope that means that even if you had a circumstance where you're kind of on the line, substantial costs or just plain costs, the culture of accommodation, hopefully this ruling will create, will kind of nudge the line a little bit more and provide more opportunities for religious employees.
Right. Yeah, and I want to come back to that in a second. We did get a question in the chat that I've heard from a number of people. I just get a chance to clarify, right? The Postal Service is a quasi-governmental institution, I guess we'll call it that. How is it that, this is not limited to government entities, but does in fact apply to Amazon and Walmart and your local hardware store, as long as it's big enough?
Yeah, so Title VII just applies to any employer. It's not just something about the government. Now, you might ask yourself, so why did they take a U.S. Postal Service case? I assume that's because it's an area, because it's a federal employee where only federal law is going to apply. Although I'm a little shaky on that. I've had some questions about why state law doesn't apply, but I suspect that's why. Because if you had state law, then it might get, depending on the jurisdiction, you might get coverage there. So it's a convenient case, useful case. But Title VII, the idea of the 1964 Civil Rights Act writ large, of which Title VII is a piece, was in order to provide regulation to private businesses and private business, in a variety of areas that wasn't otherwise covered. So it's really a form of regulating kind of in the wake of all the challenges of the Jim Crow South, segregation, all these issues that you had within the marketplace. It was meant to address those, not just government institutions or employers.
Right. One of the arguments that was not focused on a lot, certainly by the majority or even at the oral arguments, but I think was the motivation behind Justice Sotomayor writing a concurring opinion, although her concurring opinion is not crystal clear in what it's saying, was about, but the issue is about the impact of accommodations to one employee or to some employees, what the impact of that is on other employees, right? You referenced this when we were talking about the medical residency. If it's a very small residency, well, you can't force everybody else to work on Saturday, just to accommodate the one person, et cetera. What is your sense of how the court issued its ruling in this case on that particular aspect of it? How much, again, in future cases, we're going to look at not just what's the financial cost on the business, or maybe, does it or does it not get in the way of the company being able to sell its widgets, but burdens on coworkers. How do you think that factors into this in the wake of this ruling?
Yeah, this is a little bit of a puzzle. The court was like super duper clear, and I'm really curious what you have to say on this particular issue. It's going to be very hard. The court wanted to be clear that on the one hand, the text of Title VII, this is kind of what drives this inquiry. The text of Title VII says, listen, here's the deal. It's about burden on the employer's business. So any of your considerations, it has to be about some sort of accommodation that's impacting the business. Now, there are lots of ways something can impact the business. That's what the court notes. If all of a sudden I start giving out some sort of super duper weekend pass to one employee and nobody else is getting it, you can see how the other employees might get a little miffed, and it might undermine company morale in some sort of way. And people are like, well, why does he get that? I want it. I had things I need to do and you can see how that might impact a business, and maybe it might generate, such kind of contempt that it would lead to some sort of substantial costs on the business. But the court was super careful to also say employee animosity doesn't fit the bill. So if you just have a whole bunch of employees that are angry that somebody else is getting a religious accommodation, that doesn't work. The court kind of described it as that would put Title VII at war with itself. It can't be that we like accommodation, but if people are angry about accommodation, we don't give accommodation. Like, which way are you going, law? And the answer is no, we're pro accommodation if possible. Now, what is this going to mean for courts? Courts may have to stare down a couple of employees and kind of try to figure out from their statements, from testimony even, is this kind of undermining morale or is this animosity? That's tough. That's a hard thing to figure out when you're staring at somebody. Like, are they somehow justified in their, how they're reacting to this accommodation, or are they just really just being jerks?
Right.
That's hard to figure out, and I don't know how courts exactly will do that. I'm curious, kind of how you think that'll play out.
Yeah, I mean, I think it's going to depend on the kinds of accommodations that are at issue. Like, the ones that are always talked about and the ones that were most thought about in this case, right, are the ones that are most common, which are scheduling and what you might call garb and grooming, right? So the second ones are actually kind of easy to sort through, right? If a Muslim woman wants to wear a hijab or an Orthodox man wants to wear a yarmulke, it's hard to imagine that burdening the business in any material way, right? The cases that have, and there have been cases litigated about this, right, where the business has said, no, we can't have a Muslim woman wearing a headscarf at our front desk because that will somehow be off-putting to customers or clients or whatever. That clearly falls in the animosity category, whether it's on the part of the employees or it's frankly on the part of the customers. And I think the court clearly says that's just absolutely not going to fly. The scheduling ones, can be potentially more difficult, right? Because of I want to have off on Saturday also, not because I'm religious, but because I want to mow my lawn. And how far does that have to build up amongst how large a group of employees that, you end up with employees that are like not working to their full capacity and they're sort of like slow walking things, and that really impacts the operations of the business. That's going to be much more difficult. And then, frankly, something that hasn't been talked about, was not talked about by the court, and has not really been talked about at most, is you're going to have all kinds of other accommodations that are sought, right? There was a Supreme Court case last week, which got a lot more press, about the religious Christian website designer that did not want to make wedding websites for same-sex couples. And that was purely a free speech case. And the court, in a divided opinion, said the state cannot compel this web designer woman on free speech grounds to do that. Well, suppose you have a website design company that gets a contract to design a pornographic website. And you have one web designer that works in that company that says it's against my religious principles to work on this kind of website. Give me another project. And that company wants to design that website. That's not a question there. I'm not sure how much of a free speech claim that employee has in that context, because it's not his speech. It's the company doing its business. And if anything, it's the company's speech, maybe. But he would have a religious accommodation claim. And, how those kinds of scenarios will ripple through, or you have a lawyer that that works at a law firm that doesn't want to be on the defense team for some particular kind of client that's committed a particular kind of crime. There are lots of things that are not scheduling. There are lots of things that are not, what are you wearing, that are still going to fall under this standard, which I think are going to actually be the cases that might test what does it mean to disrupt the business more than Shabbos or Yom Kippur or wearing a headscarf.
Yeah, and this probably goes back to like why the first couple of cases are going to be really important. Just really outlining this. I mean, of course, Nathan, if we think back to the old standard, I mean, there was just no incentive for employers to try to actually give much thought to,
right,
can I accommodate? The answer always was, wait a minute, it's already taking me like 5 minutes to figure this out. That's like significant administrative costs. Right. That's more than a de minimis burden. I don't have to do this. Now employers will have to actually sit down and think, is this possible or is it going to be a disaster? And I think that sounds about right. That's what I presume. I don't want to speak for we as a community, but I'll say that's what I think we want from employers, to actually sit down and give a good faith attempt to see if these kinds of practices can be accommodated.
And I think it's also important to say that, while obviously we need to watch carefully and engage in whatever cases come up now in the courts, I would say, and maybe this relates to the research of the professor at Hebrew U that you referenced, far more of this is going to be hopefully positively impactful without ever seeing the daylight of a courtroom. That when the employee comes in and the manager calls up the associate general counsel, on the top floor, what am I supposed to do here? Now that associate general counsel is going to say to the manager, well, you really need to spend some time trying to figure out if you can make this work, rather than, oh, don't worry about it. If you don't want to do it, don't do it. And if those scenarios never see a courtroom, that's good by us. And that relates also to things that we are hoping to do at OU Advocacy, which not in the framework of Congress or the courts or the executive branch, although somewhat related to the executive branch, where we typically do our work, which is engage with the network of human resources professionals and employer networks, and try to engage with them in the wake of this case and educate them about the needs of our community. And we're going to do this in partnership with other faith communities, hopefully, and have them, from in the wake of this ruling, build more of a culture of accommodation, to use the term that you used, Avi. We're also going to, interestingly, have a lever into that through the government and through the executive branch, in that in May, the Biden administration released the first ever national strategy to counter anti-Semitism. And within that strategy document, the White House has directed the Labor Department, the Small Business Administration, and the Equal Employment Opportunity Commission to look at a number of things in the workplace, including what's the guidance they're putting out about religious accommodation in the workplace. And they're looking at that through the framework of combating anti-Semitism. And obviously they were anticipating that this court ruling was coming. So we're going to be working with those agencies to push on that from the government side as well. So we're really hoping that we can proactively build that culture of accommodation that you referenced. Let me just briefly look in the chat and see if there are any questions we should touch on. One question was, is this going to relate to situations beyond business, like homeowners associations that don't allow prayer meetings? That is not this statute. That's actually a different statute. Perhaps, two other statutes that we at OU Advocacy worked on that don't deal with employment, which is this case, but the Religious Freedom Restoration Act or the Religious Land Use and Institutionalized Persons Act would relate to the scenarios about prayer meetings in homes. And you could go to our website, advocacy.ou.org, to find out more information about those statutes. And then the other question I see here is that as opposed to the disability arena, and which the Americans with Disabilities Act addresses, which the questioner says, it's pretty clear. The questioner says what kind of accommodation somebody with a physical disability might need. How does this relate to pretty much anybody being able to say, my religion requires me to take off an hour from work when it's 70 degrees and sunny outside and sit in the park, something like that. That's not a new question in this arena. Avi, you want to explain how courts deal with that?
Yeah, the answer as to whether or not it's going to open the floodgates, I think, really gets back to what we mentioned before. And it's a great question. And I forget the name of the questioner, but whoever the questioner is, if you're trying to get a handle on some of this, it's probably worth poking around on the court's docket. I think you said you were a lawyer, so I can say that. And taking a look at this amicus brief that was filed by 22 states that really goes through their current standards, how they've really required more accommodation of employers, and how that's actually worked out relatively well. So I think that was a big issue. One of the reasons why some folks wanted to use the American with Disabilities Act, like we ourselves, I should probably give a plug here now, that a couple of things about our amicus brief. One, it included this push for the American with Disabilities Act. Two, it was filed by the Pepperdine Caruso School of Law, Hugh and Hazel Darling Religious Liberty Clinic, which I love dearly. I think hopefully Nathan also is starting to love dearly.
Yes.
And in addition, the brief was cited in the Supreme Court's opinion as part of this paragraph that really tried to press the point as to how the need for accommodation is very important to minority faith communities, which is, I think, exactly, what the, OU advocacy is trying to press, the ways in which our religious affiliation matters deeply in terms of the kinds of legal protections we ought to be getting. But kind of, bigger picture, thinking a little bit about, that's why you might want to use the American with Disabilities Act. Maybe that'll prevent the floodgates from opening. But I think what these states did a really great job of outlining was broader protections really are unlikely to generate this floodgates problem. That really, this kind of standard between costs and substantial costs, relatively intuitive, context-sensitive approach that, in the main, employers and employees are going to be able to work together to actually find, relatively sensible conclusions. And to the extent it ends up in state courts or courts applying state law have successfully been able to navigate these kinds of questions for quite some time.
And the other thing is there is a standard out there with regard to religion, that comes up in different contexts, whereas a court won't investigate religion itself, but it will look to see whether the person invoking something in that space has what's termed a sincerely held religious belief, and whether they've demonstrated through their behavior and their lifestyle whether that's something that they've really been faithful to as a predicate to whatever the context of the discussion is. And that is something that courts have done in different contexts over the years, and they would do it here as well if they had to. Okay. I think we've covered a lot. I don't know, Avi, if you have any other closing remarks, but
no, this was great. This is, Nathan, I know you've been working on this issue for for a while.
Too long.
Sometimes that's what it takes. And just, it's really exciting. I've said this to you before, you look at the founding documents of Orthodox advocacy from the 60s, and, there are these, there's this great introduction to a volume by Marvin Schick where he talks about they thought they were going to deal with big church state issues, but it turned out the needs of the community were trying to find ways to make sure businesses accommodated their Orthodox Jewish employees and accommodated in particular the Sabbath. And it's been a long road, which many people have worked on in terms of, I think about people like Nat Lewin, who worked a tremendous amount in terms of the actual legislation that underlies this court's decision, your work on, what do they call it? I can't even say the acronym, but various forms of legislation to try to address this issue. And it's super cool to, at the end of this story, well, it's not the end, we still have work to do, but really to have changed it, provided a standard that protects religious employees in the workplace. There's no reason that you should have to give up your religious commitments in order to participate in the workplace, to have the court use our work and hopefully to continue to use our work in order to press that point. Just just proud to be alongside you on that, and excited to see what's next.
And I and everyone at the OU are very grateful for the partnership with Avi Helfand and the Pepperdine Religious Liberty Clinic, which we really appreciated their work on this brief, and it was really a first-rate brief, which is how you get cited in a Supreme Court opinion. So thank you, Professor Michael Avi Helfand, for spending some time unpacking Groff versus DeJoy with us. And thank you all for tuning in. We wish you all a good day.